Hello, I'm Dr. Ian McCullough of Johns Hopkins University. This is a short lecture on legal considerations in social media analytics. This is not meant to be comprehensive. I am not a lawyer. These are my legal disclaimers. Learning objectives. I think it's important as we're social media analysts to become aware of some of the legal issues that might get either you in trouble, your company in trouble, and we just want to keep everybody out of jail. So the first issues, the first thing about legal issues with social media is it's a largely undefined legal field. So the rules are a little bit murky. And so what lawyers attempt to do is find more established laws in in society and see if they apply online. So the first was the idea of trespass. So when it came to web scraping, a site would say, well, hey, this is my site, my website. And so if I put data on my website and you come onto my website and take that, you have trespassed onto my property, and I can have legal damages from that. And that argument went largely unchallenged until about 2000, year 2000, and then eBay challenged Bidder's Edge, and for this idea that Bidder's Edge was trespassing. They ended up settling, but the judge held an injunction stating that that heavy bot traffic could disrupt service, like a denial of service. Now, there's two things in that. One, the issue on trespass was not addressed, right? So there was no legal determination on whether Bidder's Edge was trespassing on eBay, but they settled, right? So there was some monetary exchange. What the judge said is he's not making a ruling on trespass, but if your activity on my site disrupts the service I'm providing my paying clients or my business, then I can claim damages that you've caused me. That's the denial of service argument. There were a couple of subsequent cases on trespass, Perfect 10 versus Google and Cvent versus Eventbrite, and those were unsuccessful. So, the general case law is saying that for you to go to a website and scrape data, there is no trespass involved in that type of argument. They do say you need to be careful about disrupting the service that website is attempting to provide its customers. So the next issue comes about in 2009. Facebook sued Power.com and were citing copyright violations. So they're saying that if you were to come to my website and scrape my content, and then you're going to sell it in some way, or you're going to post in some way, well, you've copyrighted. I have a copyright on that, and therefore you can't do that. There was another case in 2013, similar one, where the Associated Press versus Meltwater sued him for scraping news sites and publishing their articles, as is. So, the general site, claims on that, or issues, or what the determinations were in these two particular cases, is that if you're going to go and scrape my content and then you're reselling it as is without doing anything to it, that's a copyright issue. If, however, you take my data, you take the facts out of my data that's publicly available, right, and then you do some analysis, you change it or modify it in some way, you combine it with something else, then it's okay. Then it's not like you're doing a copyright violation. So that's an important point. You can take the data, you can use the data as long as you're integrating it, doing something, adding some sort of value to it beyond what you're just you're getting off the site you're scraping from. Damages. This is an interesting case, the U.S. versus Arnheimer. He was basically doing identity theft, online identity theft, right? He was, going and taking people's personally identifiable information, and so he was initially convicted of, identity theft. Well, that was overturned in appeal, and his sentence was vacated because of the finding that the site that he was stealing the personally identifiable information from had no password or barrier to entry to prevent public access. So basically the fact that if I have a site and I have valuable information and I do nothing to put a password on there or nothing to kind of prevent anybody from going to the site to getting the information, then if they use that and do something is obviously wrong as identity theft, then that is okay. So this is where sites are now kind of obligated to create a password protection or some barrier to prevent you from getting there. So if you can go to the site and you can access data and you haven't had to hack a password or somehow get around their barrier to entry, you're probably okay to collect that data and use it as you please. It's when you have to actually hack a password or find a way to steal somebody else's password, or you've done something like that to get around that barrier to entry, which is probably why an organization like Twitter is going to make you have an authorization, right? It basically is, could you find an authorization online? Yeah, if you were to Google it, you'll find people's online, API key and tokens available. I mean, they're posted, and you could take those, use them, and get Twitter data. But what have you just done? You have, basically gotten around their barrier to entry, their barrier to prevent public access, and so now it's not clear that you can just get that data and do whatever you like with it, and you're free to ignore their terms of use because you found a way to get it publicly. So that's kind of both a requirement and a consideration you have to think about. Probably one of the more recent cases is QVC versus Resulti. Now this is a case where QVC is a shopping network, and Resulti created an app where basically you put in what you want and it finds the lowest price. Well, Resulti and QVC went into an agreement where Resulti had the permission to scrape QVC's website to get the prices, and QVC even agreed to pay them however many cents for every referral Resulti's app did that resulted in a QVC sale. Well, the Resulti's scraping of the QVC site was excessive, and it created a degradation in their service, denial of service, and so then, even though they had an agreement, QVC granted permission to Resulti to scrape the site. They hadn't really discussed what the rate limits were on that scraping, and QVC hadn't really set up anything to protect bots or other types of excessive scraping. Still, QVC was able to sue Resulti, and I believe that was settled out of court. But again, this is an issue where anything you're going to do that's going to damage a data provider, online site through your scraping brings you into this legal issue. So, what are your requirements from a legal standpoint? First, you can't have copyright infringement, and this is an important point. I mean, Facebook even has this on their page after their lawsuit, right? But generally, copyright, it doesn't protect the facts and ideas, but it does protect the original words, images, and express an idea. So essentially, if you take content and you change it in some way, in some meaningful way to add value, you're okay. But if you're copying and pasting as is, then you have problems. The next point, scraping cannot burden the site being scraped. You are required, essentially, to place in rate limits or maybe even vary the attribution of the hits so that you're not drawing this undue attention and resources of the company looking at you. The scraper should not gather sensitive user information such as your social security number, passport, these sorts of things. Now, again, I'll bring your attention back to that U.S. versus Arnheimer. It's unclear in this area, but I would not want to be a person that would be collecting, identity attributable information like that if I didn't have a legal reason to do so. It just places you into a very gray area that's risky. There's also this this idea of kind of getting back to the copyright infringement here, but adhere to fair use laws. So, copying of a copyrighted material for the purpose of commenting on it, criticizing it, or even making a parody of it, those are all okay. That's the fair use law of content. You cannot violate the terms of use. Now, this is a tricky area. Terms of use, it doesn't mean that because a website places up, here's my terms of use, that you're beholden to follow that, any more than if I went out into the hallway outside a classroom and I put up a sign and say, terms of use, anybody walking down this hallway owes Ian McCullough $1,000, and then I take everybody to court that walks down the hallway. No, that doesn't work, right? That's a public space, as is the internet. So for me to claim that you came into an agreement with me, we have to demonstrate 2 points. One is value consideration, so that means that something of value has to have been exchanged, which people can argue that the data has value to it, so therefore the fact that you've taken data, there's been value exchange. The other one is there has to be a meeting of the minds. So a meeting of the minds, what that means for a contract in this terms of use means that the website provider is going to have to demonstrate to a reasonable person that you and they agreed on these terms of use. Right? So there are issues where if you have like a really honest long terms of use and you just click the button, did you really read it? Well, is that your fault or is that their fault that they had this really long, fine print? And it's not clear how that happens, right? It's just going to be a judge is going to look at the agreement and make a determination. Now, I would argue that some of these things are a little more straightforward. If you're, LinkedIn or Facebook or some social media provider, and you say, hey, I don't want to allow automated scraping of my site. And what I'm going to do is I'm going to require an authorization before anybody can access the API and get data. And that authorization is there to say, I want to ensure that you understand my rules, and I've put a barrier to public access, and so the only way you can get to the data is to click the button. You're going to have a hard time convincing a judge, well, yeah, I clicked the button to get their data, but I didn't read it. I didn't agree with it. Well, why'd you do it? Right? You're going to have a hard time convincing a judge that you weren't just intentionally violating the terms of use to get their data. Not necessarily the case if you're signing up and using a site for social media, and then you haven't used that social media site in 3 years, and now you're on a project where you have a company that's dealing with this data, and you're using that for some work purpose. Well, then that becomes less clear. Did you understand the terms of use? Did the terms of use change from when you signed up and got that initial account? Did you even read it back then? Do you know? It can get a little murky, but pretty much what this issue means is if you can access data without checking a box that says, I agree to the terms of use, it's free game. You can scrape it as long as you're not using the original words, you're adding some value to it, you can pretty much do whatever you want. Soon as you have to click that box that says, hey, I agree to your terms of use, I'm going to log in, I'm going to get an authorization, as soon as you've done that, you're now basically agreeing to adhere to their terms of use in the agreement in order for the value of the data that you're getting, and that is a legal contract. When is it possible for a social media provider to take action against you or your company? So the first one is degradation of service, right? So if you have a denial of service or degradation of service, so some ideas, right? Python Scrappy package allows you to put in rate limits so that you're not overburdening the site. You're being a little more paced in how you pull data down. Providers usually have their own barriers to excessive use, like a CAPTCHA, and they're kind of obligated to do that in a sense as well. Okay, the next issue, awareness of potential unwanted scraping. So it's possible that a social media provider could say, well, they're scraping all the time, so I have to actually have an employee that's going to take the time to call them and tell them to stop, and that costs so much money. I don't know of a case where that's happened, but that's an argument a social media provider could take, and then those are damages that they can sue you for. So it's probably wise to employ some sort of non-attribution, like vary your signals of scraping, change your operating system, change up the way you're actually doing the scrape so that it doesn't draw attention to the social media provider. The third area is attacks on reputation from publications. So if you published a paper that said, LinkedIn sucks, Well, LinkedIn could argue that maybe you got their data fair and square, but now you're using it to, um, you know, basically cause libel or slander to them in the press. And so, in that case, they can say your attacks on reputation are damages to us resulting from whatever you did with our data. It's also important to note that the rules for the U.S. government are far more restrictive than for a private entity. So, some of you may work for the U.S. government, and if that's the case, then there are ridiculously restrictive laws and oversight. If you're in intelligence, you basically can't scrape media in the U.S. or on U.S. persons. If you are going to be, going on the internet and collecting data, something that would be perfectly fine from your living room, you're going to have to make sure that your organization is giving you particular authorities. And there's a lot of reasons for that. One is the type of data you can collect from social media can be very powerful. And so part of the checks and balances the U.S. government has, they don't want that to just be unchecked. So there are congressional oversight. There are tons of rules that govern how people are collecting the data. What are they doing with the data? Are they not abusing the data, etc. And so it's just an important point to note. This has been a short lecture on legal considerations dealing with social media. I'm Dr. Ian McCullough of Johns Hopkins University.